I want to thank everybody for coming today. And we have another great presentation coming with Cheryl from DREDF. I'm going to be a little indulgent here before we jump into this. Part of this is DREDF, for those of you that are not familiar with DREDF, DREDF has been the cornerstone of disability advocacy for decades and decades and decades. The other part of this is just for me personally, I had the honor of being an intern at DREDF for a number of years. As I like to say, I feel like I am the Forrest Gump of disability advocacy. So, like, I was there when a lot of this stuff was new and being implemented at DREDF. I had nothing to do with it. I worked in the background here doing ADA law and that kind of thing. But, part of this, what DREDF did for me is it really kind of set a tone for advocacy for community living here that, quite frankly, has guided me for my entire career in this area. The other thing with it, I want to do a shout out to somebody really special to me, which is a woman named Pam Stenberg. She was the parent advocate from 1979 until 1990, something or another. I don't have the slide in front of me. In a way, she's a lot of what DREDF was all about, because a lot of the folks that founded DREDF and made DREDF what it was were parents and persons with disabilities who were realizing that there must be a different way, when it comes to persons with disabilities and what true inclusion is. So in many ways, we're standing on those parents' shoulders, if I can be that self-indulgent. So, Cheryl, I'm really excited about this. And there's a couple of things I hope that our viewers get today out of this. One is obviously talking about this important part of the disability world, which deals with education and IDEA and 504 and all of that stuff. And I think, one of my favorite sayings is that if you have an attorney or an advocate who's doing this work that doesn't know the difference between an IEP and an SUV, yeah, probably should get somebody else, because even for those of us who don't directly do this work, this is a key part of the whole disability community, and that affects the families and persons with disabilities we work with. So it's something that we really should understand where to go when there's a problem, and also maybe take a minute of homage to people who sacrificed a lot of their lives to make this happen. I mean, Cheryl, what do you think?
No, absolutely. I think on the previous slide, let me just jump back for a second. I included a link to our news about some of our recent accomplishments as an organization. And I hope that you'll take a minute to look at that when we have a little more time. But everyone who works at DREDF is a person with a disability or has a child with a disability, or both. And so, yes, we are standing on the shoulders of giants. I'd also shout out to Arlene Mayerson and Mary Lou Breslin and some of the other folks at DREDF, Marilyn Golden, who worked so hard to make sure that disability rights were seen as civil rights, and more importantly, I think as basic human rights. And so, although I'm not focusing so much on that in this presentation, I think it's always important to keep in our minds why we're doing what we're doing. And there is such dearth of information out there for legal services access for families around these issues, partly because, for example, many folks in our legal aid organizations just don't understand or haven't had a lot of training around special education and so on. So I'm really glad for those of you who have signed up, and sorry about the snafu. Thank you for attending, because no matter what area of law or advocacy you are involved in, one thing we know for sure is that families of children with disabilities or suspected disabilities who have an advocate or an attorney, their IEPs look really different. And that's unfortunate. It should not be true, but it is. And so hopefully we'll empower you a little bit to make sure that we can level the playing field for everybody.
Great. And Cheryl, since we are doing a little bit of this on the fly, would you prefer that we hold questions till the end or, um,
Yeah, I think it would be great if we could hold questions till the end. If it's something that, you is really, really important and you want to put it in the chat, that would be great because I will try to look at it. I'm just not too good at the multitasking of looking at the chat window.
I will
And
do
if you,
Amy's job today, hopefully a little better than I have already here. So if you do have questions, please put them in the question and answer, the Q&A thing there. And anyway,
all right,
let's
shall I take it
learn
away?
about IDEA and 504 and all that cool stuff.
All right. Good morning, everybody. And again, I'm sorry about the snafu. I actually sat for 15 minutes drinking my coffee, thinking that I had 15 extra minutes. And so here we go. First of all, Dale did a great job of explaining a little bit about DREDF as an organization. And you can review the previous slide. You'll get these slides, and it will include as PDFs, and it will include all the links that I've included here today. But it is an organization that doesn't just focus on education. We do healthcare, policy, communications. We were involved, for example, in a high impact litigation involving Netflix, where they tried to say that the internet back in the day was not a place and therefore not covered under the Americans with Disabilities Act. So there's all kinds of stuff going on at DREDF. But where I work is in the Parent Training and Information Center. So the first thing I want to make sure that you all know is that in every state and territory in this country, there is a parent training and information center funded by the United States Department of Education, at least in part. And the reason that they exist is that when a lot of these laws were being passed and implemented, the first thing, and Dale already alluded to this, the first thing that many parents and disabled people said was, oh, it's really great to have all these rights, but this is complicated. How would we ever know how to use them? And so the PTIs are funded not to provide legal advice. We're very careful about that, but to provide information, technical assistance, and training for families, including youth, and at no cost. So even if you have a family that's relocating, you can always refer them. I've included the link about how to find your parent center. And there is one in every state and territory. And that's where I work because DREDF holds a grant to serve 30 counties in Northern California. So all the way from, the Central Valley, San Joaquin, all the way up to the coast with our partners who are also Parent Training and Information Center. So I'm going to start, here's a quick overview of our agenda. I'm going to start and get right into it rather than take the time to review the agenda, but hopefully I'll get to all this stuff. I want to quickly go over some basic definitions because I think if you don't have these definitions, some of what the slides moving forward will say might be a little bit confusing. First of all, there is a very important legal obligation for every public school or school that takes, federal funds to conduct what's called child find. And child find just means that there is this legal obligation to locate children who may need an evaluation to see whether they need more services, support, and equal access. Again, it doesn't guarantee that someone's eligible, but it does say that our schools have this obligation. I'll talk more about this stuff. Compensatory education, I only include it because in our post-COVID world, it's been such an ongoing issue. So many students with disabilities were impacted much more significantly than other groups, just because all of their IEP services either came to a grinding halt or were delivered remotely, which, as you can imagine, really doesn't work for a lot of our students. Getting speech therapy when you're 3 years old on the internet was just really not something that worked very well. So there is a provision in these laws where you can request compensatory education services, and these aren't funds generally, but they are services that are provided to help make up for a failure to follow the law, a failure to implement the IEP, and so on. FAPE I'm going to talk more about, but this is really the cornerstone of the two major laws we're talking about today. The right to a free, appropriate public education. There's a slightly different definition for each of them. I'll go through that, but just it's a good term to know. And when I say, and I often do fall into saying the district or a public school, what I mean is what's called the local education agency, LEA, and that can include court schools, county schools, including non-public schools when a student is placed there by a public school with their IEP. So whenever I say the school district, just know, and this includes charter schools. And sometimes charter schools don't seem to understand fully that they are subject to all of these laws. And so just to clarify, they absolutely are. LRE means least restrictive environment. We'll come back to that. It's a very, very important part of these protective laws. An IEP stands for an individualized education program. When I use the term parent, I mean the person who holds ed rights. So you might be a court-appointed special advocate who holds education rights. You might be a legal guardian or kinship provider who holds education rights. There are even some kids who don't have anyone to act in that role, and the school district will appoint someone, and that often can be problematic for various reasons. And finally, special education. I just want to define it because we'll talk more about it, and just emphasize to you that special education is not a place. Special education is a set of services, supports, specially designed instruction delivered to the student in their least restrictive environment so that they can make meaningful progress toward appropriately ambitious goals. And I'm actually quoting from a recent Supreme Court case here, the Andrew F. case. So special education applies to students who are ages 3 to 22 in California. And in California, we have this unique system of regional centers, which also serve our little ones, 0 until they turn 3, through early intervention or what's called early start. I'm not emphasizing that today, but it's just important to know that's actually still part of the IDEA. It's just a different part. So starting at age 3, special education kicks in, and that's what we're going to be talking about in a minute. Oops, Okay, so there's 3 key laws we're going to focus on today. They are the Family Education Rights Privacy Act, also known as FERPA. I'll get to that first. Then we'll talk about Section 504, and also I'll briefly mention its relationship to the Americans with Disabilities Act. And then there is the Individuals with Disabilities Education Act, IDEA. And all of them have a relationship with each other. So we'll also get into that. So let's start with FERPA. And as you know, if you work in the legal field, we're all about acronyms. Everybody loves acronyms. So FERPA is a good one to know. Many of you may have heard of HIPAA, which is the medical privacy rights. That is a guarantee for everyone when they're interacting with the healthcare system. And FERPA applies to the education system. It lays out privacy rights for students and their families. It includes these rights, and this is often the very first thing we're going to do at DREDF when a family calls us in the Parent Training and Information Center and says, I don't think that the school district is supporting my child enough, or here's what's going wrong, is to make sure that the parent has access and understands what's in that student's record. So FERPA says that, parents and any student at 18 and this is a little important carve out because sometimes our students go to college or participate in college programs before they're 18, has the right to access and review any and all records that the district or charter school keeps. The school district can charge for copies. Sometimes these records are, these are all the evaluations, all the attendance, all the discipline records, anything they hold. So if the parent says, well, I need copies, the district can say, well, we want to charge you. So I always want to make sure that people understand that if that's a burden on a family to pay for those, and the parent points out in writing that that is a burden, that the district must provide them at no cost, in part because it's so important to the meaningful participation of the parent. In California, and every state has a different requirement. In fact, in the federal law, it's 30 days maximum, but here in California, it's only 5. You have the right to access those records within 5 business days of the time you get a written request. So that's just an important thing to know. And I think if a family is coming to you, whether it's a youth or it's a parent, that understanding that they have the right to see these records is really important. It's quite surprising sometimes for a family to actually see their child's records and realize, number one, that there's things in there that are incorrect, or that they've never seen, but also sometimes things that the parent has provided and asked be included in the student's record that never got in. So it's an important right. The other thing that FERPA allows for is if the school district got it wrong, if the records are incorrect, a parent can challenge that, or a young person can challenge that and say that they want the records corrected, there's incorrect information in there. Importantly, even if the school district does an investigation and says, oh, we got your request and that you think that we got this wrong, we disagree and we're not willing to change it, and people can file a complaint under FERPA. But even if they aren't successful in getting the record changed, they always have the right to put their side of the story into the record. And this can be so important when you're dealing with behavior issues and discipline, because school records follow our students from place to place, school to school, state to state. And, if your child had a discipline issue, maybe that involved some physical aggression, but it was after months of being bullied where the parent was consistently trying to get help for that student. And, you'll see a discipline report that says they're being suspended for aggression without any of that background. It can be very helpful to put, everything that led up to it and what failures in the IEP or 504 process you want to point to, et cetera. So we included sample letters here, just so FERPA is really an important part. And it doesn't just apply to students with disabilities. This is an education right for all students, including students in college, et cetera.
Now,
all right.
So I have one administrative duty I have to do before we go through the next slide, which is this program has been accredited by the state bar for continuing education credit. And there are 3 codes that you need to record. I'll make sure that everybody has a link to where to get the sheet as far as for recording this, so you can get continuing education credit. But our first code, and there'll be 3, our first code is 6411. So that's MCLE code number 1. That is 6411. And if you don't have the form in front of you, just record that here and you can enter that in later. So Cheryl, tell us about 504.
Thanks. And actually, Amy, because she's nothing if not extremely efficient, sent me those slides, and she inserted them for me, and then I made some corrections, and it looks like they fell off. So thank you for pointing that out. And in the final version that you'll get, those slides will be there.
They will.
Okay. So what the heck is Section 504 of the Rehabilitation Act of 1973? It's a mouthful, and generally we just talk about 504 as shorthand. So this is not an education law. This is a federal anti-discrimination civil rights law, and people fought really hard for this law to go into effect. In fact, there's a wonderful film, Crip Camp, that talks about some of the life of some of the activists and how they got involved in this. And also there's the history of 504 and so on. So it was hard fought because it was mirrored on the civil rights laws of the 60s. And the idea was, wait a minute, if we can't, if we're discriminated against, if someone can deny us housing or access to their building or access to school because of our disability related needs, then our civil rights are being infringed on. So that's really the purpose of 504. It isn't just in an education setting. It applies to everyone in this country, and super, super important employment and in college settings and in any sort of public entity. It levels the playing field. That's the purpose of 504, so that in an education setting, which is what I'm going to focus on here, students with disabilities can participate in and benefit from education like their non-disabled peers. So that's this definition I mentioned earlier of FAPE, FAPE, free appropriate public education. When it comes to Section 504, what that term means is equal access, right? So we want to make sure, for example, a call we got at DREDF, we get these every year, unfortunately, was, gosh, my student with a disability will need one more semester in order to finish their credits, and they're being denied the right to walk the stage with all of their peers, or wheel stage, or as the case may be. And they'll never have the opportunity to go through the graduation ceremony with the people they've been in school with, often since 5, and yet they're being denied that, even though we've slowed down their education a little bit specifically so that they can have this extra time to meet these graduation requirements. So that's an example of discrimination. Another example would be, and again, we got a call this year, like every year, our school is doing a field trip to XYZ location, but they're telling me that my second grader can't go because they can't afford a wheelchair accessible bus. And that's clearly discriminatory, and it's generally pretty easy to get that fixed if you know where to go and how to navigate that. And so that's one of the ways that parents are very disadvantaged in these situations, is that someone at maybe a lower level who's inadequately trained or has a misunderstanding of the law will say, in the case I'm mentioning, it was the actual school site council said, oh no, we don't have the funds. This field trip is being funded through this money, and we can't afford to get an accessible bus. So it just took a couple of phone calls, but it's the kind of thing that should not be happening, because students with disabilities have equal access. So I always think of it in my mind as kind of the wheelchair access law, because it's about removing barriers. So if you wheel up to school as a kindergartner on the first day of school and there's no ramp, you can't get in. And metaphorically, there's all kinds of situations where you can't get in. So if a child has difficulty with attention and focus and impulsivity, and they need a break every 30 minutes so that they can move around a little and refocus, and they don't get that, well, then they don't have equal access to their education like their non-disabled peers. There's often questions about what's the relationship between Section 504 and the Americans with Disabilities Act. The difference is that 504 applies to any entity that receives federal funds, and the Americans with Disability Act applies to virtually every entity in the country except for churches and private clubs. So generally, any of our schools, unless they're a religious school, will be covered either by Section 504 or the ADA, or both. And I'm not going to spend a lot of time talking about the ADA here, because generally in the school setting, a 504 plan mirrors what would be happening there. So what are the legal rights? Oops, sorry about the extra bullet. What are the legal rights? The right to FAPE. Again, this is the definition. Schools must meet the educational needs of these children as well as they meet the educational needs of non-disabled children. Section 504 has a very broad, flexible definition of impairment or disability, and it is really about an impairment of a major life function, and that can be something like learning, but reading, but can also be something like communicating, eating, walking, etc. If that gets in the way of their ability to access and benefit from their education, then they should be eligible under 504. And so I included the legal rights under 504 just so that you have them, because there's often this idea that people have that Section 504 doesn't come with any procedural safeguards or ways to challenge school districts' decisions and so on. And that's not true. And of course, our friends at Disability Rights California, who put out so many great publications, have a resource that I've included here in their Special Education Rights and Responsibilities Handbook, which talks about these rights. Okay. How the heck does a family request a 504 plan? We tell people this all the time, everything in writing. And if you're, in the legal field, you already know this, but it's kind of amazing how much other issues can get in the way of parents realizing that. And just to clarify what I mean, In some cultures, it's considered extremely disrespectful to challenge a school or an educator. Parents are often worried about things like, gosh, I'm worried about my immigration status. And if I start asking for help for my child, is that going to come up? And the answer is no, but it's a fear that people have. And so we really try to emphasize to families, and hope you will too, that you want to do everything in writing, because that's the way you make sure you're communicating clearly. You want to request answers in writing. So it's all about putting things in writing. Generally, the parent will submit a request to the school site administrator. Usually we mean the principal. Sometimes it's the school counselor. Just ask who's in charge of 504 at this school. But also know that every school district or charter school has someone who's in charge of 504 for the whole shebang. So, if you're working with the principal and things are just not going well, or the family comes to you and they say, they told us our child's not eligible unless we go get a medical diagnosis, which isn't true. Then you can reach out above the school site at the district administration level. And often that will solve the problem, because that person tends to be very highly trained. There is a lot of what I think of as kind of folklore out there about 504 that our schools and educators seem to think. And I really have come to realize they genuinely think this. So they will think that you cannot get a 504 plan unless you have a health condition that's been medically diagnosed. That's not true. They also think that 504 is kind of something you should try before a child gets evaluated for special education, or that it's a consolation prize if the student doesn't qualify for an IEP. And those things aren't true. And I'll get more into that in general. And finally, there's a misconception out there that the U.S. Department of Education and Office of Civil Rights have clarified now a few times, which is that, well, the difference between a 504 plan and an IEP is that with a 504 plan, you can't get services. And that's just not true. That's not the difference. And I'll go over what the differences are in a minute. But it is not true that you can't have access to special education support through a 504 plan. You can, but you may be butting up against someone who really thinks that's true. And that's why a well-worded letter from someone like yourselves can be so helpful. Citing the education code, helping the parent to say, I can't write it for you, because here at DREDF, we would never write a letter for the family, because that would be acting as if we were representing them. But we certainly have sample letters, and we certainly could say, well, if you're going to write a letter and say that that's not correct, here's the education code you could use. Here's the law you could quote. And that can be enormously helpful for families. So what's in a 504 plan? It is all about removing these barriers, right? So it still has to be individualized. We do not say things like, here's the 504 plan for a child with autism. Here's your 504 plan for a child who has a mobility impairment. That is not what we do. We look at each child not on the basis of their disability or impairment, but on that particular child's strengths and needs. So 504 plans can include accommodations, education support, even through special education, and even services. I've seen students with a 504 plan have a one-to-one aide, because the family made the argument that although they might not qualify for special education, they can't really access their education without an aide. So just know that it's much more flexible than our schools and educators are trained to understand in many cases. It's typical things you might see in a 504 plan would be things like, extra time to complete an assignment. My kid had a 504 plan that said, he gets everything in by Monday morning after a weekend, because especially in high school, there were often so many assignments, and he needed to complete them to learn in his case, but he needed extra time to finish them. So he had that extra time over the weekend without penalty. They can include things like taking a break, a regular movement break, sending the child on an errand every hour so they can, get up and move around. Could be an accommodation. They can also include things like nursing care, a nut-free lunch table, care around their medical conditions like diabetes at school. DREDF many years ago was involved in a lawsuit involving diabetes care, just a shout out to us. And we so many families were calling us to say that they were told that if they couldn't come and provide their child with their diabetes care, then the child couldn't come to school that day, that they didn't have a legal obligation to provide access through, diabetes health care. And so ultimately now we have rules in California that say that you can provide a non-medical professional with this kind of training. And, this really came in part or in large part from parents who said, wait a minute, I couldn't take my child home from the hospital after they were diagnosed with diabetes unless I got trained about how to do this. And now you're telling me that only a registered nurse at the school, which is, my child might need insulin, or blood sugar testing once or twice a day, that only that person can do, and yet you couldn't get us out of the hospital fast enough without showing us quickly how to manage all this. So the other thing I have been seeing more and more, and again, I think this is in part a sign of the times post-COVID, but also the stressors on our kids around mental health, is that, more and more we're hearing from families whose kids maybe have been hospitalized in a mental health crisis or even any kind of healthcare crisis, but particularly around mental health care. And sometimes the family will say, my child doesn't necessarily need, special education services, but they definitely need a plan where we get together to create equal access by sort of slowly coming back to school, reducing the demands, et cetera. And so this kind of school reintegration plan or mental health plan and so on. Again, 504 plans can include services like speech therapy or behavior support plans, occupational therapy, school counseling, and parent training and consultation, which can be incredibly important. If you think about something like a child who needs assistive technology, which is another one of our possible supports down at the bottom, if you're the parent and you don't know how to help your child with the device or the software that they've been assigned, that really can impact you. Other parents are able to help their kids with homework, without having to understand how to use, voice to text or text to voice or whatever the system is. And then environmental accommodations can include things like a distraction-free room for testing, an alternative location when outside air quality is poor. A lot of kids with asthma may qualify under Section 504 if it's significant enough that it's impacting their educational access. Things like a standing desk for students who need to be able to move around, and a sensory toolkit. Those are all ways in which we can accommodate students. And finally, as I said, assistive technology, which is right next door to DREDF at the Ed Roberts campus here in Berkeley, is the Center for Accessible Technology. And I've learned so much from them, and it's really pretty incredible how much technology, software, hardware, specialized programs is exploding, but it's also a place where I think a lot of our schools are about a decade behind in knowing what's out there. And so if they don't know it exists and they don't keep somebody trained and up to date, then, and a parent doesn't necessarily know, often doesn't know that it exists, then the student doesn't access it. So we want to make sure that we provide this kind of support. And more districts are appointing someone who they call their district assistive technologist, who really is responsible for this and keeping up with it and can provide consultation to parents and training to students and so on. So that's what typically is in a 504 plan, but I just want to mention or emphasize again that it's individualized. Okay, so what the heck is the relationship between Section 504 and special education? Do students who have an IEP because they're eligible for special education, do they also need a 504 plan so they're not discriminated against? And the answer is generally no, because special education includes accommodations as necessary. And generally what happens is that we build the 504 plan into the IEP. And you'll often see this in the accommodations page of an IEP. It'll say things like extra time for tests or a separate setting, or what happens when there's state testing, how are we going to accommodate the student, extra large print, access to Braille, whatever it is. And so they aren't mutually exclusive. Students, if you think about this graphic, so there's all the students at a school or in a classroom. Some of those students may be eligible under Section 504 and have a 504 plan. And then there's an even more smaller subset generally of students who might be eligible for special education, which will include their 504 anti-discrimination piece as well. All right. Dale, are there any pressing questions before I launch into special education? This is sort
You
of the
must
meat
be
of the
knocking
presentation.
it out of the park here
Okay.
so far, but I'm sure we will.
All right. All right. So now let's talk about special education. And I said this at the beginning. I'm going to say it again. It's not a place. Uh, there is this real misconception that I think sometimes relates to ableism, right? So that disability discrimination piece, like racism, the idea that, if you know a person with autism, then you know them because they have autism. That's not the purpose of special education, is to slap a label on a student so then you can just pull out your autism support plan, your ADHD support plan, your orthopedic impairment support plan. That's not how it works at all. So what special education is it comes out of the Individuals with Disabilities Education Act, the IDEA. That's a federal education law. Again, remember I said 504 is a federal law, but it's not an education law. It's an anti-discrimination law. So students, in order to be eligible for special education, have to be evaluated and fit into one of 13 eligibility categories of disability. These are not medical categories. So when a family comes to you and says, I can't believe it, my child has an autism diagnosis from the international head of autism research from Stanford University, but the school district evaluated and said my child does not have autism. What's really going on there is that the school district doesn't diagnose anyone. The school district evaluates to see whether the child can be slipped into one of these 13 categories of disability. They're really broad categories, and they have educational definitions that are actually in education code. So it is possible, although usually with some pushback, it can be addressed, that a student might have a medical diagnosis, but the school's position is that's all well and fine and dandy, but we don't see an educational impact at school. And therefore, we don't see that they're eligible, or we don't see, you think you may have a DSM, 5 category of autism in the medical record, but when the child's at school, we don't see that those difficulties are significant enough to impact their communication, their social skills, their learning, their academics, and so on. And so it can be challenging for a family to understand this, and it's really frustrating. And a lot of times it's because everybody's, especially on the education side of the house, is splitting hairs. So they'll say, well, we don't see educational impact because the child's passing all their classes. So I always point people to the title of this slide. It's the Education Act. It's not the Academic Act. So students who have educational impact, that can be ability to work in the group, ability to even attend school when, for example, their anxiety or depression is so severe they can't even walk in the door without a panic attack. It's not just about it, it can be their behavior because it's so significantly impacting their ability to participate at school, benefit from their education. So it is not the Individuals with Disabilities Academic Act. And gifted students can have an IEP. So the 2 prongs of eligibility here is that the student fits into one of these 13 categories, and I'll give you an example. A specific learning disability, which is one of the most common eligibility categories. Again, these are educational eligibility categories. That's a pretty broad statement, specific learning disability. It can include dyslexia, or reading disability. It can include dysgraphia in terms of like your ability to get what you're thinking onto paper, your writing. It can include auditory processing, how you process in language, not a hearing impairment, but how you process language. It can include things like what's it called? I was having a moment. Dyscalculia, so a problem with understanding certain aspects of math. And school districts will often say, well, it's not our job to dig down deeply enough to identify exactly what the learning disability is. We'll just say they have a learning disability that impacts their reading or their writing or their math or their hearing and their auditory processing or their visual processing, et cetera. And so I'm going to come back to that, but I just want you to keep that in mind. So specific learning disability is one category. You could slip students in there under any number of subcategories. Autism, we call it in California, it's an autistic-like disorder. The school district is not diagnosing the child with autism. They're saying that the problems that they're having at school are consistent with this educational definition of autism. And because they fit into a category, that isn't enough. They have to also need specialized support and instruction to benefit from their education. In other words, the student can't have access or benefit from their learning unless they receive specialized instruction. Again, not just academic instruction. And there's a lot of misunderstanding about that. Whoops, sorry. Sometimes my mouse is too sensitive. All right, so what the heck is the purpose of an IEP? The purpose is to provide a free, appropriate public education. Again, see that word FAPE? But the definition for special education is a little bit different than it is for a 504 plan. The definition is that FAPE is a program of supports and services that's individualized to the unique needs of the child. And an IEP goes a little further than a 504 plan does, and these are some of the key differences I'm going to go into in just a minute. But they still have a right to get protection under 504 and to not be discriminated against. But in addition to that, they get the benefit of special education, and that includes goals that we want them to meet in a year, reevaluation every 3 years, a case manager to see that their services are being delivered appropriately and consistently, progress reports toward their goals, and a whole bunch more procedural safeguards are parent rights that families can use. And I'm going to get into those because I think this is something that you will encounter. If a family comes into you, these are often the categories where you can be thinking, where does the issues this family's bringing to us here, where do they fit in? The first is that every student has a right to an appropriate evaluation or assessment. And again, this is triggered by a written request for evaluation that can come from the school, can come from the teacher, can come from the parent, can come from the caregiver, but it has to be in writing. And so for our families, for example, who have limited English proficiency, this can be a big issue because they won't understand that they can request an evaluation in Spanish. That they can call their parent training information center to get help from one of our bilingual advocates to put their concerns in writing. We have a ton of sample letters on our DREDF website, including a sample letter about how to request an evaluation in both Spanish and English, and we can get it in other languages as well. But the right to an appropriate evaluation or assessment is really important, and I'm going to come back to that topic. They have a right to this free and appropriate public education, individualized to their unique needs. They have a right to be in their least restrictive environment. So the research is pretty clear. First of all, I teach parents that one thing that they could say in an IEP meeting when someone's proposing that their child be in a more restrictive educational setting and the parent's not in agreement with that, is there are no special day classes. And I know this is part of what Dale, works so hard on. There are no special day classes out in the community and in adulthood, right? We want to live together. We want to integrate people into their community to the greatest extent possible. We want to make sure they can participate, contribute, benefit, no matter what their disability is or how significantly it might impact some parts of their everyday lives. We want to make sure that we're not segregating people, because that's what it is segregation. And so this right to least restrictive environment is often a concern of a family. And in fact, I think one of the things that sometimes I would go so far as to use the word deployed, because sometimes I do think it is deployed, is that when a parent asks for a special education evaluation, they get pushback because especially, or in many cases, because they are a more marginalized minority family or family with immigration concerns or whatever, homeless families, whatever the case may be, foster youth, that, that child's not special ed, as if special education automatically implies less than, not equal, etc. And that's the whole purpose of these laws, is actually to undo that long history and legacy of exclusion and segregation. So I would never argue with someone who said, yes, but it's been used to segregate kids ever since it came into effect, because that is true. Sometimes, you can go to some of these schools that are non-public schools where school districts have placed a child with an IEP in a segregated setting where every single child in the program or young person has a disability. And, you look around and you think, wow, there's certainly an overrepresentation of certain students here in this setting, whether it's Black and brown students, whether it's students with limited English, whatever it is. So it does happen, but part of our job, from DREDF's perspective, part of our job is to make sure that we teach people that that's not how it's supposed to work. So, we're not dealing with, a perfect world. This happens. But sometimes what families are told is, oh, this will be so much better for the child because they'll get more services. There'll only be, 6 to 8 students in the class, and they'll get a lot more help. And that may or may not be true. But I say to families, please go visit and make sure you see it. Ask how many students who are in this setting get back to a less restrictive setting within a year or two of being placed there. So that it's not a place that we're sending a student away to, because that's not what special education is about. Another important cornerstone of this law is that the parent and the student, starting at 18 or the age of majority, which here in California is 18, but they have to start being invited no later than 16, that they're involved in the decision-making process. And one point I want to make about that is that participation here doesn't just mean that you're a guest at your child's IEP meeting. Parents are a critical member of the IEP team. This is a difference between 504 and special education, because actually 504 technically doesn't even require parent consent. I think public schools generally recognize that it's absolutely critical and best practice to include the parent and make sure they buy in, but it's not required that they come to the meeting or be invited to the meeting and so on. So it's, with an IEP, we're talking about a fundamental right to be involved, to provide consent, to be a team member. And what we tell families is, you are the expert on your own child. So, for example, we often see that a parent will request an evaluation to see if their child is eligible for services. And the school district will say, oh, we don't see that there's a need. In fact, we actually think the problem is you're not making your kid come to school enough. If their attendance was better, they wouldn't be struggling academically. So we don't see a need. And for the family to understand that connecting the dots by asking for an evaluation that is based on the fact that my child has so much trouble going to school that they're literally having a panic attack and can't go into the building. Did you know I'm driving up in the morning to drop them off and they can't get out of the car some days? Did you know that their depression is so severe? Did you know that because of their autism, their sensory overwhelm is so significant that just walking into this big, busy public school setting is too much? And so connecting those dots to say this is related to the disability. It's not just related to these other factors. Or say for foster children, you'll often see the excuse that we're not going to evaluate them because the child just didn't go to school consistently, or the parent didn't make sure that they were participating, and really they've just gotten behind because they didn't receive general education instruction. That might be true. Or because they've been moved from school to school so much. Our foster youth are highly, highly mobile. But the problem is that, because you're a child who is in foster care does not mean that you also might not be a child who has a disability. And so we don't want to use one category to exclude another category, especially if the student needs that support. So the parent and the student are essential parts of the IEP special education decision-making process, but it comes up a lot that parents will tell us that they really feel unwelcome, or that they were invited, but like as a guest, that they weren't heard. That when they raised concerns, everybody nodded and smiled and said, "Yeah, that sounds really hard," but didn't address their concerns and so on. And IDEA special education really is not intended for a parent or a student to be a guest. They're intended for them to be part of the process. And then finally, special education comes with procedural safeguards. So a whole bunch of specific rights, and I included at the end of this presentation a lot of resources, including what your parent rights are in California. Our experience is that many parents do not read those procedural safeguards, that notice of parent rights. It's given to a parent when you ask for an evaluation or when the team meets at the annual IEP meeting that happens every year. But part of the reason why they don't read it is it's not very parent friendly. And secondly, it is often not translated into their language. So how the heck can you read your rights if you can't read the document? And school districts really should be explaining those rights to the parent when they're handing them that brochure. But because everyone's so busy and these meetings are often scheduled for a very limited amount of time, they'll say, "Here's a copy of your parent rights. Anyway, let's move on." Or do you have any questions? And the parent hasn't even had a chance to read them yet. So just remember that there's an important set of rights that are documented in that little brochure. So this is, again, what's unique to special education as opposed to a 504 plan. Again, this well-defined participation right, really robust procedural safeguards that are, you can file a state complaint, you can file an administrative complaint, you can ask for a hearing, there's mediation, there's all kinds of steps along the way. An IEP brings case management to the student. 504 generally does not. Goals are written based on each individual student and where they are and where we want them to be, and then they're reported on. Also, the right to an independent educational evaluation. I think there are some situations under Section 504 where families have been able to get an independent educational evaluation, but it's really spelled out in special education law, in IDEA. In other words, we've created a system where we say that the school district does an evaluation to determine whether a student is eligible. And then we've said that if the student is eligible, whatever help they need, the school district must fund. And then we've underfunded special education to the tune of, I think it's last time I looked, it was funded at like 15, 16% of what it actually costs the school district to implement it. And so there's this, at least from a parent's perspective, there's this concern about conflict of interest. Are you looking to exclude students from special education because they might need costly services? That may or may not be true, but parents worry about that. And an independent educational evaluation gives the family the right to get a second opinion when they don't agree with the school district's evaluation, and to get that at public expense. And I'll talk a little bit more about that. And finally, and this is where, Dale and I have intersected quite a lot over the years, special education has very specific and important rights around transition planning. Starting at age 16 in California, there has to be a transition plan in the IEP document itself. Some students can stay in special education services until 22, unless they earn a regular high school diploma. And importantly, here in California now, we have an alternate path to a diploma that I'll come back to. But there are students who continue to work toward regular high school graduation requirements until they're 22. They have the right to do that. There are students who aren't working toward a regular diploma, but are maybe focusing more on their functional life skills, their community integration, and so on, and they can stay in special education until 22. So what exits you from special education is either getting a regular high school diploma, turning 22 here in California, or the family or youth saying, I don't want services anymore, and or an evaluation that says you're no longer eligible for special ed. They can't just say, oh, it's great, your student met their goals, so they're no longer eligible for special education. Okay. Why are you not advancing? Let's see. There we go. All right, I included this. It's not real clear, and I'm not going to go through it. I just want to emphasize special education has very clear timelines in most cases. And so here they are. One of those important rights is a timeline for how quickly a school district must respond when the family asks for an evaluation. Once a child is eligible, how quickly their IEP needs to be put in place. Once they have an IEP, that there's an annual IEP meeting to discuss their progress toward their goals and so on. There's also the parent's right, and this is important for you all to know, a parent's right to request an IEP meeting to check in with the team if they have concerns. So I've included all these timelines for you, but I won't go through them just in the interest of time.
Okay, and then Cheryl, I'm going to interrupt real quick because we're ready for our second code here. So for those of you that are taking this for credit, and once again, it's been approved by the California State Bar for 1.5 units of MCLE credit. Here, our second code is 5041. So that's appropriate since we're talking about 504 plans. 5041. Okay. By the way, Cheryl, we did have a short question real quick. Maybe we can slip that in. Is there a standardized comprehensive evaluation, or how do you ensure that they're evaluating in the most comprehensive way possible?
That is a great question. And I will say that, again, I want to point to the I in IEP. It's individualized. So there is no one set of testing standards that are in place. The way it's supposed to work is that the school gets a request for evaluation. It can include from their own team. And by the way, if the school team wants to meet to discuss whether a child should be evaluated, that's just fine, but it doesn't stop any of the timelines that I talked about a couple slides ago. However, a parent concerns letter can go a long way to explaining what the concerns are. Sometimes you'll see an evaluation where it was clear that all they were looking at is something like an emotional disturbance, or all they were looking at was to see whether the student, met eligibility under autism. And that's not how this works. They're supposed to evaluate in all areas of suspected disability. And so there is no one set of tests, but generally they need to be comprehensive enough and from a variety of sources. And I think that's really important. So that would include not just giving them, something like, the fancy names, the Woodcock-Johnson test, or a Wechsler test of, how they're processing information and their cognition. It includes observing the student, talking to the teacher or teachers, talking to the parent, sending the parent, forms to fill out, reviewing information from other sources, so outside providers and so on, and really digging deeply enough. So if you're doing an evaluation and you see, there's some red flags that this child might have dyslexia, for example, then, the evaluator, generally the educational psychologist, should then go dig deeper. And so sometimes what we see with these evaluations, and I could do a whole presentation just on evaluations, so I won't spend too much more time. But one of the common things that you'll see is the school psychologist report will say things like, well, they scored, in the solidly average in the area of their cognitive ability. So they clearly don't have an intellectual disability or a learning disability, and they're not eligible. But when you look closely at the report, and again, parents don't understand how this stuff works in most cases, what it will actually show is that maybe in visual processing, they were in the 90th percentile. But when it came to executive functioning or planning and organizing and so on, maybe they were in the bottom 5th percentile. Well, if you average the two, that child might look average, but that's not what they're supposed to be doing. They're supposed to be looking for educational impact. And if they see a red flag, like a score that low, then they probably need to go a little further. So what we tell parents is, you don't have to be an expert. You're not a psychologist. You're not a neuropsych. But what you can say is this report didn't answer the questions we had about what's getting in our child's way, and seems to be cursory, or didn't really, that nobody even bothered to interview the student or talk to us or observe our child in the educational setting, or observe our child during lunchtime and recess, which is where they're having the most difficulty. So it needs to be comprehensive. So there isn't a particular list, but you should be able to look at it and say, well, the significant concerns and questions the parents has been answered. Oh, sorry. All right. So, in terms of advocacy, and I'm rushing a little because I know that most of you expected that this would end at 12:30, and I'm happy to stay over, Dale, but I also don't want to, assume that everybody can stay. So helping families document issues and problems in this process, and I think this is true for both 504 plans and for IEPs, or special education eligible students, emphasizing that it needs to be in writing. So I tell parents all the time, oh, you had a conversation with the teacher yesterday about how she really thinks there's something going on with this child and there might be a learning disability. And she said, might be a good idea to do more testing. You might want to come home and write, thank you for meeting with me today. My understanding is that you're seeing these problems. I agree with you. You said you were going to make a referral for special education. I just want to make sure that happens. Did I get this right? Did I, was this your understanding? So that there's a written way. We tell parents, if you could absolutely not say a word out loud, how would you explain what's hard for your child? Are there examples, work products? Take a video of the child's meltdowns during homework. That's another common reason why the schools will say a child isn't eligible, is we don't see it at school. Well, if the child can't do their homework without meltdowns, or the parents sitting with them the whole time to keep them on task, then there is educational impact. It happens to be at home, but it's directly related to education. So making sure that families understand how to bring their issues to the team in a way that speaks the language of education, and not just the language of, well, at home we're having constant behavior problems. And what do you mean you aren't seeing problems at school? Here's it only happens around educational or homework, or because a child doesn't want to go on a field trip and they're anxious about it or whatever. Making sure that you also request that the school district respond in writing, in the form of this thing called prior written notice. I included a link because it's such an important right, and so misunderstood and underutilized. So I tell families all the time, if you go to an IEP meeting and they're talking about your child's behavior and they're saying, that they are really, really creating distractions for other kids in the classroom, or they're constantly being sent out of the classroom, and you say, maybe we should do an evaluation to see, whether my child needs a behavior intervention planner. Maybe we should do a certain kind of evaluation that's really focusing on behavior. And the district says, well, we'll think about it. The team says, well, maybe we'll get back to you. That it's important to say, well, when can I expect prior written notice? Because I really need an answer in writing. And then again, making sure that parents can participate is important. So reminding them and empowering them about their rights. Look, you're a key member of the team here. They need you at that table. You know the child better than anyone. As a young person, you know yourself the best. And making sure that comes into, the discussion. So you're not being a problem when you ask for something to be translated. You're not being difficult when you disagree. You can say, I'm sorry, I respectfully disagree. And here's why. And you can give an example. And, how to participate in these meetings effectively. And it's an art. Okay. More than anything, remember that there is a parent training and information center in every state and territory, so they can contact us. We always want parents to understand, for special education situations, that they have 3 ways they can sign a document. They can disagree. So the school district may say, we got your request for an evaluation because your child has a recent diagnosis of autism from UCSF. We are declining to evaluate. Their grades are fine and we don't see any educational impact. So the parent might simply write back and say, we disagree with that decision and we want an independent evaluation or we want this other thing done. They have the right to say, I agree to the IEP, but with some exceptions. For example, I agree my child's eligible for services and all the accommodations and goals look great, but I don't agree to move them to a more restrictive educational setting. And I want a Part 2 IEP meeting to discuss this because I don't think that that's appropriate. And then they can sign that they fully agree with the IEP. It's also really important to help families document compliance issues. I actually, when the parent comes into my office, I generally make like 3 columns with them as they're telling me about everything that's going wrong. And first of all, teaching them to issue spot is really important because the family will tell you everything they don't like. And I'll say, if you could only fix 3 things right now, what would they be? Oh, well, it's the placement. Oh, it's, that they've been denied speech therapy or whatever. But my columns are generally, is this a disagreement? They're saying my child doesn't need occupational therapy. I absolutely think my child needs occupational therapy. It's a disagreement. Okay, if it's not that, or in addition, is there also an issue around compliance? In other words, something like, doesn't IDEA require that you evaluate within 60 days of the time that the parent gives informed consent and signs an assessment plan? And gee, the district took 100 days. They're out of compliance with the legal timelines there. Aren't they required to do X, Y, and Z? That's a state complaint, typically, not a disagreement where they might want a hearing. And so I really try to help them understand, okay, that issue has to do with actually following the law or implementing the law. And then finally, is it a discrimination issue? Right. And it could be that the parent has issues in each of those areas. So the parent may say, well, and they don't, because of their behavior, they can't go on field trips. Because the district says they don't have an aide they could send with them for the, overnight field trip or whatever. So then we're talking about discrimination. So just to help them and teach them to do that kind of issue spotting, because there's different pathways to solving problems depending on what kind of an issue that you have. And finally, helping families focus on the strengths and successes of their child and helping young people understand how to self-advocate and speak about their strengths as well. One thing that I often say, especially when I'm working with youth, is no meeting should ever start without a discussion about what your strengths are. Because we all use our strengths to overcome what's hard for us, right? That's what growing up is all about, is figuring out, okay, these are my challenges, but what are the strengths I can use to get around them, overcome them, whatever the case is. And so when you see an IEP that doesn't include information about what the student's strengths are, call it out, because it changes the tone of the meeting to say, hey, wait a minute, before we get started, for parents, it's really hard to hear everything your child's struggling with. And certainly for a young person, it's really hard to sit in a meeting where you're hearing everything that you're not on track doing. But if you start with, these are the things, and it's not Susie's a cute little girl with freckles and pigtails. That's not a strength. A strength would be, she's an excellent communicator and self-advocate, and she's empathetic, real strengths. That's an important part of this process. So here's, I put it in here for you, these sort of issues. The other thing I tell families all the time is, and I suppose that in, legal practice, this is often part of the interview process as well, is what do you want to see happen? Not just what's going wrong. What do you want to see happen? You may not know every option that could be available for your child, but you might say, but I know the placement they're in now isn't giving them any strong academics, isn't helping them make progress. They're still not reading. I want them to be able to read, and to, really make sure that it's based on, this is where we're going. This is what I want to see happen. Not just here's everything you guys are doing wrong, because I think it can really change the tone of the meetings when you're focused on solutions and not just on problems. In all fairness, our schools are short-staffed, underfunded. There's a lot of incredible educators and administrators who really want to do the right thing, but there are so many barriers right now. And so sometimes just knowing what it is that you want to see changed, rather than just spending an IEP meeting saying everything they're doing wrong, can make the meetings go better. I included this two resources that I love. One is Disagreements with Districts Toolkit, again from Disability Rights California. It's a great resource and it's California specific, which is nice. And then the Center for Appropriate Dispute Resolution in Special Education is a national organization, and they do a lot of education around what your parent rights are. They do it on the educator side of the house. They support them, and they do it for families, and they've got some great resources as well. So look at that, 12:28. We have 2 whole minutes. Again, I'm happy to stay over, but that's the broad overview, and I hope that the takeaways are that advocacy really matters. And I can look at an IEP or a 504 plan for a child who has the same disability label that impacts them in pretty similar ways, sometimes in the same district, sometimes even in the same school district, sometimes even in the same classroom, and look at 2 very different documents. And the difference will be whether or not a child has someone advocating for them. And here's the problem. Special education in particular is built on this premise that every child has a parent who can advocate for them. And that's just not true. Our parents have faced many, many barriers. And it's really unfortunate that unless they can access legal help, very often they just don't feel comfortable pushing back. They worry about retaliation. They worry about all kinds of things. So helping them know how to use the process effectively, how to support them is really important. I included, and I think Dale, if you can drop it into the chat, that would be great, our evaluation form, but I'm happy to take questions at this point if you want to go for it.
And I will drop that in the chat. Let me just mention, this is our last code here. So for those of you that are taking this for credit, code number 3 is 1218. That's 1218. And once again, I put in the chat instructions about how to apply for credit, whatever, going through this. And I also will drop in the evaluation form as well, except that I'm trying to take it off the wrong place. Cheryl, I've got a couple of questions before we jump into this. It seems like in a lot of ways, whenever you're dealing with 504 plans and IEPs, it seems like in a lot of cases we're in combat mode. Do we always have to be in combat mode? Is there a way maybe not to, or any suggestions about that?
Yeah, sure. And I think I would preface this answer by saying that unfortunately, no one ever calls us at DREDF because everything's working great. And so we tend to have a somewhat, distorted perception. But absolutely. And I think that's why helping families know what their rights are is so important. A family may say to me, no, I don't want to file a complaint against my school district. I just want them to do the right thing. It's not critical to me that they're out of the legal timeline by 10 days. I just want to know, what are they committing to fix it? So I think knowing your rights and how to use your rights is one way to keep things positive. Parents, I certainly have had situations where parents walk into a meeting very combative, very angry and frustrating. I think I remember myself as a parent, and often share this, how difficult these meetings are, right? As with some of our younger kids, it's often the first time that anyone is telling you your child has a disability. It can be emotionally upsetting, flooding. We all have misperceptions or stereotypes about what that might mean. Sometimes you feel like the school isn't hearing you, but really they're just looking through an educational lens, and you're looking through, the family and home lens. And so, using some of these advocacy tips can be really helpful. I included in the resources some information about how to write a good letter. I think putting things in writing, but not, I'm writing because you're totally doing the wrong thing and here's, everything's going wrong, but rather emphasizing, like, here's my evidence or documentation for what's going on or what my concerns are. And I just want to work and collaborate with the team about some possible solutions. It frames the problem so much differently than if you sort of come into the meeting, guns blazing. And I would say that's also true for school districts, because I think it goes both ways. I've certainly gone into IEP meetings where it feels like the district was hostile from the get-go. Maybe it's because the parent has pushed back in the past, maybe because they feel very strongly about standing behind their decisions and so on, and they might be right. But the problem is homeschool collaboration is the single best predictor of how any kid's going to do in school, right? That this relationship, this trust, and we say, be hard on the issues, be soft on the people, because especially our frontline folks right now, their caseloads are really, really difficult to manage. They may not be training. I think in Oakland Unified, a few years ago, when I looked, about something like 50% of their teachers who were special education teachers teaching the students with really significant disabilities in the moderate severe type special day classes didn't yet hold a credential because there's such a teaching shortage. They were learning on the fly. And I'm not interested in beating up that teacher who stepped into that situation. I might say to them, how can I support you to get the training you need, to get the support you need? So yeah, I think it's really important to keep that in mind.
I think that's super important here because all of our programs, whether regional center schools, programs, whatever, they're all under tremendous pressure, and I think it's really important to also support the schools. Now, there's these things called SELPAs and CACs. What the heck are those?
Yeah, well, California likes to do its own thing.
Of course.
So in California, the way that we sort of funnel financing and consultation and training to some extent to our schools is through this thing called a SELPA. So SELPA stands for Special Education Local Plan Area. Again, it's acronym after acronym in special education. It's frustrating. And the SELPAs often work, for example, in Berkeley, where DREDF lives. Berkeley is part of the North Region SELPA, and it includes 5 different school districts who share resources with each other and whose funding all come through the North Region SELPA. And, they can do things like facilitate an IEP meeting. Sometimes, there's so much water under the bridge, the process has broken down, the SELPA might come and facilitate that meeting, make sure, not to be on one side or the other, but just to make sure the process is staying positive and student-centered and focused and so on. These resources are some of the ones that we rely on the most. This resource that says communicating with your child's school through letter writing is a great resource. We also included some templates that you can look at and provide to families to help them know, like, what should a letter look like? I often say, when you write a letter to a school, could you please try to remember, you may be really frustrated and upset. Can you please try to remember that you want to start maybe with what's working? Thank you. The progress my child's made in the area of reading this year is great and so on. However, I have some concerns and here's what they are. There's also information on how to obtain this independent educational evaluation, this second opinion at district expense. I especially love, and I don't necessarily send them to parents because they can be rather technical, but I often send these guidance letter from the Office of Special Education Programs, which is at the U.S. Department of Education. They have guidance letters they've issued usually to schools about different issues where someone has said, well, do we have to grant an independent evaluation under this circumstances, or do we have to do this, or do we have to do that? And so those are really helpful resources as well.
there certainly is a lot of education you need to be able to pull this off. I mean, one of the things I've come to discover is that simple and disability don't seem to be two words that go together. I mean, but there's a lot involved in to be able to do this kind of advocacy. We do have a question here, which is, with the expansion of the traditional kindergarten and district preschools, I hear a lot of the districts cannot meet the LRE because of fewer classrooms and children to draw from for peer access. Can you touch on this issue a bit?
Yeah, thank you, Melinda. That's a great question. I didn't spend a lot of time talking about the preschool piece, and I shouldn't leave without saying that in the resources is information about our website, and we do free trainings on different topics, and this is one of them. But the preschool stuff is really hard because our kids in California are served by regional centers until they're 3 if they're early intervention eligible. And then they transition to the school district in most cases at 3. And now we have transitional kindergarten starting, for kids who are like 4. There's rules about the ages, but generally, our 4-year-olds. And all of that may be going on, but none of it changes the federal law or the obligation to provide equal access and services to kids who qualify under 504 too, not just, preschoolers can provide 504 support and are required to follow that law. My own child, my youngest, had a lot of medical issues and was in a private preschool, but our public school provided some support through an IEP because the child had a G-tube and had some special medical needs and couldn't participate. So the shorter answer to your question is, I always tell parents and I tell educators when I'm training them, I will do everything I can. If you want someone to be at Legislative Action Day about getting more funding to special ed, I'm there. But as a parent, my job is to advocate for my child to get what they need. And your funding issues do not change your obligation to make sure my child who's in TK, who qualifies for special education, doesn't get the support that they need. And my child still has a right to a one-on-one aid if they need that to participate. They shouldn't have to be sent off to a different school altogether and not be in the TK program when this is their first school experience, and we want kids with their typical peers if possible. The research is unequivocal that kids who are in less restrictive settings in the general education setting do best, but it's not just them, it's all the kids in the classroom. So I would just say that if this issue comes up, well, we don't have enough placements, we don't have enough supports or whatever, then what I say to the family is, your job is to advocate for what your child needs so they can participate. And that doesn't mean that you need to be a jerk about it or hostile or whatever, but we certainly see families who are successful, often with attorney help, unfortunately, in getting a one-on-one aid for a private preschool, getting their child placed in a program that is, in a regular public preschool, but with the support they need. So it can be done, but it's really important to make sure that you know what you can ask for, and to remember that the INIEP means that individualized to that child's unique needs. If the child needs it to be in TK, then it's on the district. And how they solve that problem, I support being creative, I support being flexible, but it needs to get solved.
So generally speaking, and I'm sure we could spend another an hour and a half, which we won't, just so you folks know that we can't afford it in and of itself is not an answer, much like regional centers.
Absolutely. And I go back to that issue, that issue spotting practice with families, right? If we know that these resources are difficult, that doesn't mean we don't advocate for our child to get them, but it does mean that, we decide what are our priorities? What are the things is this the hill you want to die on? Right. And because, we're in it for the long run. Unlike the schools from year to year, they're trying to help that child that year make progress and participate and so on. But in most cases, the child will have a whole new teacher and sometimes a whole new school the following year. And so it's the parent, again, in the broadest sense, the caregiver, the guardian, who has the long view of not only the child's previous history, but also thinks about where they're going to be. I used to sit at the end of my kid's bed and think about, where are we going to be when he's 30? What is it going to look like? And so to me, I always tell parents that, remind the team that, like, look, I have the long view. You have certain legal obligations and so on. But I want to make sure that we remember the purpose of special education. And I will quote it mostly because it's so important. The purpose of special education, and this is what Congress wrote in the IDEA, is to prepare students for future education, employment, and independent living. That's the purpose. It's not to get through first grade. It's not to, get a high school diploma. And by the way, I mentioned this and I didn't get into it, but if you have questions about the new pathway to a high school diploma that is a diploma in every sense of the word, but uses a different set of criteria here in California, let me know. I did a training on it a few months ago. I can send you the training. But
I was just going to say, DREDF, and by the way, Disability Rights California as well. They just have some fabulous materials and that kind of thing. Cheryl, I didn't mean to interrupt you, but it's part of this is when you're looking for help or trying to get your head around this. And once again, you've put it in the materials. We'll make sure it's available with the recording. Is that a lot of these resources are incredibly valuable. Here we have about 5 minutes before we hit the hour and a half, so that which is for credit. So but anyway, Cheryl, I interrupted you. You were saying.
No, you said it. I just want you to know that if you don't do anything else, you may or may not take a case, right? You may send somebody. I didn't put it in the resources and I should have, so I'll add it, Dale, that the Council of Parent Attorneys and Advocates, which has so much special education expertise and is a great referral if you don't know this area of law well, but you recognize that there's definitely issues. So it's a great way for families to know what attorneys and advocates are available in their area and on what topics. But more than anything else, if all that you do is empower the family is to say, you are the expert about your child. What you're describing sounds like, you really want to address it. It sounds like you don't feel heard. And here's, you can contact your parent training and information center. Here's some resources you can use. And to let people know how important their participation is. And then I always tell parents, and also I'll end with this, we also got to pay it forward. We've got to get involved in these community advisory committee meetings. We've got to make sure that we improve the system for everyone. We've got to make sure that, because we know doesn't mean our refugee family next door who just came to the country with a child with a significant disability related need for their child, that they may not know it. So let's make sure that we pass it on.
I'd like to address just one last thing before we close it out. And Cheryl, you've done a magnificent job. By the way, considering that maybe everything didn't run as smoothly as it should have on our end, but we'll do that. You mentioned something, and maybe this is unfair to close on this, but you mentioned something about a transition plan, right? And oftentimes when we're talking about transition plans, oftentimes we're going to see in California a shift from the schools to the regional centers and that kind of thing. Once again, any thoughts about, because that's a really important period here, that movement as folks become adults. Any thoughts about transition plans?
Oh, it's one of my favorite things to talk about, train about. It's something that the state of California in particular has not been great at, is following the requirements of the federal law in this respect. I say this, we want to move. There's nothing more powerful than seeing a young person with a disability run their own IEP meeting, advocate for themselves, even when they're, struggling to communicate. But, they can tell us whether it's verbally or through in other ways that a situation isn't working for them. So the transition to adulthood often doesn't include the self-advocacy piece, which is a great IEP goal. It often doesn't include information about how do we move the parent from the driver's seat into the, and get the student in the driver's seat. That's what we're doing with all teenagers, and our kids are kids first. They're young people first. They have all the same issues. You've heard my transition spiel before, Dale, but why do we leave out, adapted sex ed? Why do we leave out, if information about how to interact with the police for kids who are at high risk of having really serious encounters and are often misunderstood? So, yeah, transition really matters. We do a training on transition to adulthood. The kids and young people have a lot of rights in that process, but it's one of those places where California just needs to do a better job, and there's a lot of training needs and a lot of misunderstanding. It's often just feels like they threw a cookie cutter plan out there because they just didn't know what else to do. And there is a lot that we can do to challenge that and push back.
Okay, well, we have run out of time here. First off, I want to thank you, Cheryl, for doing a magnificent job. The other thing is, I want to thank all the advocates, both the parents and the persons with disabilities and the legislators, and everyone who worked so hard with DREDF, who was, key in making this all happen. And, even with all the challenges and everything that we're facing today, we are really standing on the shoulders of advocates. And, so anyway, Cheryl, you can have the last word here, but I know this won't be the last time we talk.
Yeah, my last word is to thank you guys. We often have parents who come to us and say, how do I help my young person with a disability transition to adulthood? Should I conserve them? Should I help them, keep their rights, but how could I then support them? All those other alternatives. And so I actually just want to thank you guys for the work you do. And it's a really great collaboration, I think. And feel free, any of you, we serve physicians, we do trainings for new pediatric residents and so on. You're always welcome to call us with a question, and feel free to do that.
Okay, and then in closing, we will put in for those of you at this point that are watching the recording here, there is an evaluation form for DREDF itself above and beyond the MCLE credit for this program, which I will make sure that it is in the description with the video if you're watching this. It's really important to fill that out. One is the DREDF is asking for your input, but also you do have funders and they want to know somebody's involved here. So this is one way of supporting DREDF, although I bet you a check wouldn't hurt also. But anyway, that's a discussion for
absolutely. You can see on our website how to donate, and we're always very happy to get that
okay
support.
With that,
all right,
thank you so much and happy advocating.
All right, take care.